I am Michael Diamond, for those who don't know me. I co-chair with Bill Baker the program committee, and we are pleased to have helped put together this program today. Barbara Reeves has agreed to chair the program and to moderate the panel. The topic is the need for special rules for technology arbitrations. I'm going to introduce Barbara, and Barbara will introduce her panel. Barbara is a mediator and arbitrator in domestic and international cases, including antitrust, employment, class actions, litigations, mergers, acquisitions, partnerships, intellectual property rights, patents, trademarks, copyrights, trade secrets, cybersecurity, environmental cases, and the one non-tech area is sports law, unless you do gaming. She practices with JAMS and is based in LA. She's president-elect of the College of Commercial Arbitrators and received her law degree cum laude from the Harvard Law School and graduated after me. So she's younger than I am.
Thank you very much, Michael. Thank you, everybody, for agreeing that we could get started a few minutes early. We do have two of our participants are 6 and 7 hours ahead of us, approximately, in New York, and even farther ahead or 5 or 6 hours ahead anyway. So let me start quickly by introducing everybody. I'll start with Dr. Patricia Shaughnessy. She comes to us from Stockholm, where it is already pushing 7 o'clock at night on a Friday night. And thank you for being with us, Patricia. She's an associate professor at Stockholm University and is involved in international disputes and commercial law. She's also an arbitrator, an expert, a consultant, and very active in this field in many legal development projects in many countries. She's on the ICC Court of Arbitration, on the Georgian International Arbitration Center, and the Tehran Regional International Center, for something that's really different from what most of us are familiar with. She's formerly been the vice chair of the SCC, which is Swedish Arbitration Institute. I think I've got that right. And she was involved and was a government appointed expert in the last revisions to the Swedish Arbitration Act. She received her PhD, which is also an SJD, at Stockholm University. Thank you, Patricia. Sticking to Europe for a minute, we've also got Duarte Enrique, who's a lawyer and arbitrator based in Lisbon, Portugal, which is one of those countries that I've never figured out why they are on the other side of the channel from England, but still on English, on Greenwich Mean Time, rather than an hour later. So with him, it's only approaching 6 at night now. He's a full-time arbitrator and mediator, focusing on the same humongous list of things that we all do, which is intellectual property, technology, that's why he's here, entertainment and employment disputes. He's a fellow in the CCA and a AAA master mediator, so he arbitrates and mediates, and an SVAMC tech list appointee like many of us. He's also an adjunct professor at New York Law School and a practitioner in residence at George Mason University School of Law. So he knows a lot about this stuff. In addition to doing it, he teaches it. And one of the reasons he's so knowledgeable in this field is he got his bachelor's degree in chemistry and physics from Harvard, which means he's one of those tech people who really knows what he's talking about, as well as his JD from New York University. I'm sorry, I just read Theo's bio. Okay, we can often tell the difference between them. You know, sorry, I've got my list in the wrong order. Well, you've now heard me introduce Theo while Duarte was sitting there and saying, say what? Okay, so that was Theo. Theo, wave to us so we know you're not offended.
I got promoted.
You've been, yes. So,
but I'm not from Portugal, just to be clear.
I know. Theo is from New York.
New Jersey, actually.
Exactly. Yes. And so he's on the East Coast time. And then we have Duarte. Sorry, Duarte, now we'll try this again. He's a lawyer and arbitrator based in Lisbon, as I started to say, and a founding member of Victoria Associates. He's on the board of directors of this organization, as you know, having been listening to him for those of you at the meeting so far. He's a member of the International Advisory Board of the VIAC, chairman of the Insurance Arbitration Committee Center, rather, in Lisbon. He's listed as an arbitrator and works for many organizations, ICDR, VIAC, CTAC, HKIAC, and SIAC. He specializes in several areas such as banking and finance, investment disputes, business and commercial, mergers and acquisitions, agency and distribution, construction, intellectual property. And if you, so in other words, if you've got anything in those areas, he knows it all. He's knowledgeable. He received his law degree from the Law School of Lisbon University. So we have this group assembled, and now let me turn to our program. The topic is, as you heard, special rules for technology disputes. It's not all that different from the topic that's going to be discussed later this week by the arbitration program. Hold on while I pull this up. Okay, by the program that our group is putting on in live and in person in New York. And because we have a relatively small group online, and I don't know how many of you are in the room live and in person, but I'm thinking it's we're close enough or cozy enough that if there are questions as we go along, maybe somebody who's physically present there in the room can let us know, maybe come up to the podium at some point, which is all that we can see online, and let us know that there's a question. And we'd like this to be interactive. We've structured it to be interactive among the four of us already. And but we'll certainly welcome questions, thoughts, ideas, out of the box, crazy ideas, whatever, anything new is interesting, because we got started thinking about, we all do technology disputes. Do they need special rules? On the one hand, there are organizations that are promoting special rules. On the other hand, there are organizations and people such as myself who believe it would be better to use general rules, but have different procedures in there, which give greater authority to the arbitrators to control the way the case is progressing. But it's something that we're all dealing with now. I used as an example, as we were getting started, the fact that I had one tech arbitration that was in and out in less than 5 months. And I have another one that is still trying to get out after more than 2 years. They range in size and complexity, so it's difficult to put all tech arbitrations into one box. But many of us do recognize that there are various similarities to them, and maybe we could use some special rules. So let me start with Duarte. I think I've got your name right this time. What is so special about technology disputes that makes them distinct from otherwise general commercial disputes?
Hi, Barbara. Thank you so much for your kind words and the promotion. It was really unexpected. But before going into that question, let me clarify why Portugal is on the same time zone as London. Because if you go to a globe, you can see that Portugal is clearly within the Greenwich meridian. What we cannot understand is why Spain is not in the London time zone, because the Greenwich passes almost 100 kilometers from the Pyrenees. So all the entire Iberian Peninsula is under the London time zone. So, but having said that, let's go to the to our subject here and to this question. I could start by saying that, as we discussed previously, we could say that technology-related disputes are those that require a speedy, cost-effective resolution of a dispute with the appropriate expertise and a flexible process to do so. But if I can graduate these particularities, how should I say, features, these features of arbitration that interest the most to arbitration practitioners, I could, well, and from 1 to 10, I could well say that speed in the process would be around 7, the cost would be around 8, confidentiality and no discovery for some would be 9, and expertise would be 10. So I would place the complexity of the disputes as the primary feature of arbitration. And let me exemplify with two cases. One of them is an arbitration where I was involved in the past, and it was dealing with the copyright infringement on the computer-based platform. So in order to ascertain whether there was a copy, whether there was an infringement, we needed to dig into the source code of the platform, of the software platform. So, and I had to go through a specific training to properly understand and read the source code. And this was a readable form of a source code. We cannot imagine how can we interpret a language that is not readable. And as you know, it is only in a binary code with ones and zeros. So if we can have the chance and the luck to have a readable source code, it is really hard and difficult to understand it. So this really requires expertise and requires specific knowledge to be able to understand the dispute, be able to understand the subject of the dispute. The other example comes also from Portugal and has some particular and interesting features, that is this case, which relates to a legal regime that is now defunct, but for almost 8 years there was a mandatory process to go to arbitration when you had to dispute infringement of patents on medicines. So whenever there was a patent on medicines at stake, you had to go to arbitration. And of course, the pool of arbitrators here was very reduced. It was not more than 20 arbitrators that were experts in this field. And the fact is that because this regime was mandatory, around 1,000 arbitrations went to cases went to arbitration, and therefore you can imagine the accumulation of cases by a single arbitrator. And there was a case of an arbitrator who got 50 appointments by the same law firm. This is a total exaggeration. This is a nonsense. But otherwise, other cases that do not have so many cases, or other arbitrators, and that were challenged, they were excused by the courts in those challenges, because the court said, well, the pool of experts is really tiny, so you cannot resort to any other arbitrator, and therefore the expertise of the arbitrators was an excuse to overcome this challenge on arbitrators, and was also, of course, a way to promote and to have a better way to resort to experts in solving disputes by arbitration.
But Duarte, Duarte, I have a question. But couldn't that also have been solved by either the lawyers or the arbitrators selecting an expert? In other words, then you'd have an arbitrator who's a good managerial general arbitrator, and who knows some technology, but who has hired the equivalent of a the secretary that you might use on an ICC case to be the expert, or is that just layering too many people onto it?
Of course, these cases do not dispense with the use of experts and expert reports, but that's not the point, because if you appoint an expert, for instance, a pharmaceutical technician to solve a dispute, he probably will not be able to solve a dispute, because this involves interpretation and application of special rules. So therefore, experts are not enough to solve the case, and you need people who has a sufficient grip on the conduct of cases and in the managing of interpreting and applying the law to have a proper resolution of the dispute. So of course, I don't think that experts can be dispensed with in these cases, but the fact that you have an arbitrator that is expert and understands the language that is being talked there in arbitration helps a lot, and certainly improves the efficiency of the arbitration. Because like that case that I had, once I had the training, I can now say where we should look into to see if there is and what tools we should use to ascertain whether there was an infringement.
So one of the points that you've made is the need for speed. And we all recognize that in many of the cases we deal with involve startups. And
Exactly.
you know, I'm dealing with a case now where they're not only a startup, they're heavily invested in cryptocurrency, which means there are a lot of problems going on. And I have an emergency motion suddenly come up because they need to get some of these disputes resolved so that they can keep their investors calm. They need investors to come in and give them, you know, more money, and investors don't like investing in startups that are invested in litigation. Patricia, if I can jump to you for a minute, on this need for speed, how do you go about getting emergency relief in arbitration and expedited arbitrations? Can you do it with general rules? Is that another reason for wanting more special technology rules, such as the proposed UNCITRAL rules that were mentioned earlier?
Thank you. Well, being a true academic, let me start by definition. And I always get a little concerned when I hear the word rule being used as some kind of general category. And when I think of a rule, I think that it is going to have a prescriptive or prohibitive effects, like the ICC rules of arbitration or such. And I think that we need to be careful about putting into that category all kinds of techniques, procedures, policies, different things that can be used. And one good example, if I take that now to a more specific area, and that is I don't want to turn this into a discussion about the work of the UNCITRAL Working Group 2, but we can say in the work of UNCITRAL Working Group 2, looking at the current work, at the last meeting being in October last month, and that is looking at the potential adaptation of procedures that could be used under the UNCITRAL rules for tech disputes. And the commission, which gave the mandate to Working Group 2 for its work going forward and gave that mandate in its July meeting, has put together that the Working Group 2 should look at developing early dismissal, either as a standalone suggestion or integrated into the notes on organizing arbitral procedures. So it's not suggested that it become a separate rule, but that it be integrated. And it seems to be more likely that it would take the form into the notes, the soft law form, so that it would not get such a starring role. And then if we look at what UNCITRAL is also to look at, and that is the work that was done previous to the commission and brought to the commission on potential adaptations of procedures for tech disputes. So it's not suggested, well, there were some initial discussions of whether or not there should be a separate set of potential opt-in tech provisions in the UNCITRAL rules, but I don't think there's an appetite for actually changing the UNCITRAL rules and introducing a new set of rules. So these would be somehow integrated in, and there's discussions on that. And related to that, which complicates this whole system, so you're getting, I'm sorry, a confusing answer, is the commission gave the mandate to also consider adjudication, which assuming that not everyone is fully familiar with adjudication, it's usually thought as something which is done in the UK and in Australia and in construction disputes. But the idea of adjudication, which would be more of almost an expert determination, similar to what the SEC introduced a year ago with its SEC Express. The adjudication is a pre-arbitral proceeding, and it's suggested then that parties could agree to having 2 stages. So they would have this adjudicative fast process. And then if there was a dissatisfaction, you could see it kind of like a FIDIC nod, notice of dissatisfaction, then go into the arbitral process. So these are not actual suggestions for distinct rules, although you will see in, for example, the Tashnet International Arbitration Center introduced over a year ago, separate set of tech rules, and you see those discussed. But that's not what UNCITRAL is doing. And there's a bit of an inherent messiness in bringing together the consideration in the UNCITRAL work to the parties may opt in and agree to an appendix, special provisions for expedited arbitration procedures, known as the EAPS. So that's an appendix to the rules, not actual rules that the parties can agree to. And then bringing into that also this idea of early dismissal and adjudication, which the parties could opt into. So that the legal character and what these would be becomes a little bit messy. And going back to what you indicated, Barbara, do we need more rules, or could we use the discretion which is given by the existing rules to provide in guidance, appendixes, other instruments, tools that could be adapted to the needs of tech disputes? So, for example, in the UNCITRAL working group in October, there were discussions on the early dismissal, which may be attractive if one of the parties, typically the respondent or could be claimant on a counterclaim, claims that the claim has no merit and should be dismissed. You can think of kind of like a motion for summary judgment. That many would say exists under the UNCITRAL rules, Article 17, which gives broad discretion to the arbitrators to conduct the proceedings, or similar provisions under different arbitration rules where the arbitrators had broad discretion, so that it doesn't actually require a specific rule, that you could use the procedures, you could introduce them. Parties could, through model arbitration clauses, they could contract into using these different mechanisms. That's a little bit dangerous. I think we all know in the area of multi-tier arbitration clauses that suggesting that parties pre-dispute contract into these different tools comes at a risk for very problematic, potentially difficult to implement arbitration clauses. So going back now to the idea of speed, I think that
Oops. Did Patricia freeze or did I freeze? Patricia froze? All right, she's up there on the upper peninsula, up there in Sweden. Patricia, if you can hear us, you've frozen. Not to comment on what the weather might be like in Sweden right now. All right, I'll speak for a minute or two while she readjusts her technology and hope that mine doesn't go out. But because one of the questions, and maybe Thea, you can pick up on this, is I like rules that give the arbitrator authority, because when the parties come to you in arbitration, they usually don't like each other. They're not willing to sit there, unless you get excellent lawyers, and agree on procedures. They'd rather, they're each focused on their own client. And when the rules and when the arbitration clause got adopted, it was often written by somebody who doesn't know anything about arbitration, by the deal lawyers who were focused on the deal and how much money and what intellectual property was being transferred and weren't really paying attention to the arbitration clause. So Theo, what are your thoughts about what the arbitrators can do, or how do we get more power, or what we can do to aid the parties when they get to us?
Well, I think that in general, first of all, when you're trying to introduce rule sets to parties for the very first time, when they first appear before you, they're just totally befuddled. Like in those ad hoc proceedings where it's always important to actually agree upon a rule set if the clause doesn't talk about it, I point to them, to the non-administered rules that exist out there, but they all look at me with blank stares and the like. So I think the important thing rather is to sort of set up the parties so that they can actually engage in a fruitful discussion as the process is being designed in a way that makes sense for that particular dispute. So some of the things I like to do is to, even before I actually meet with them, either through a case manager or through direct communications, I would encourage the parties to meet and confer in advance of any kind of preliminary hearing with me on how to efficiently and expeditiously run this proceeding to ensure that the tribunal, am going to be up to speed on any technology issues, for example. I kind of call it out right from the beginning. And I also try to encourage them to think about the need for expert witnesses. I know we touched upon this before with Duarte, early on, and whether a joint expert witness or some kind of tribunal expert witness would make sense for the case. I don't push either way. I just want them to think about it, and whether or not and how these experts are going to access and manipulate the data that's going to be ultimately produced in this case, and maybe in the possession of one party and not the other, for example. In that vein, I do suggest, if I'm aware of it, I do suggest a council look at any number of potential applicable rules, right? I mean, I'm aware of the fact that the AAA has promulgated multiple sets of different kinds of rules. It's actually kind of quite hard to keep track of them. In fact, I think I had totally forgotten until this panel was being organized. Bill Baker had reminded me that the AAA actually had these supplemental patent rules. I knew about them, but I hadn't really used them in any case. I looked at them, and they're purportedly supposed to apply presumptively unless the parties object, but I've never once had a case manager tell me in a patent case, oh, by the way, Theo, don't forget about the patent rules. I never had a party come to me and saying, hey, maybe we should apply these supplemental patent rules from the AAA. But I think if you are aware of such bodies of rules, or for example, the federal district courts have these patent pilot programs that have special rules. If you have those rules, you might point them out to the parties in advance of the preliminary hearing so they have a chance to look at them and see whether or not it makes sense to apply some or all of those rules in the case, particularly in the area of contention exchange. Like I'll just resort to patent cases as an example. Infringement contentions, invalidity contentions, those are important to get clear up front so that you know exactly what people are fighting about. And these rules have actually developed ways in which parties should exchange that kind of contention or kind of information. So I think that's all very, very helpful. But I'm kind of in your camp, Barbara. I kind of think that the general rules that exist out there, so long as they provide sufficient discretion to the arbitrators to have managerial authority over the case, and coupled with arbitrators who are trained well, right? I mean, we can't just let the arbitrators kind of go off and exercise discretion without proper training, but if they have the training to be good managers, that they're aware of other resources, maybe all we have to really do is to incorporate some of these other special rules or special procedures as part of the discretion that the arbitrator uses when you exercise and fill out, for example, the procedural orders.
Yeah, I think, and let me pause for a minute. And Bill Seward, if you're here, I see, can you see whether Patricia can get back in, whether she's trying to get in? She sent me an email that says she's lost her connection, but she's trying to get back in. So if you can keep an eye on her and let her in if you see her trying to get in. So I think that one of the things I liked about the AAA patent rules, if anyone wants to take a look at them, is what they really do is give you a long checklist of what to do at the preliminary hearing, what to consider. And if the arbitrator takes that list in advance and sends it to the parties, because you can't assume that the parties will have read the rules always, send it to the parties and say, in advance of our preliminary hearing, our initial case management conference, whatever you call it, here is a list of items that we will be discussing. That helps them get prepared. And I also like, under the general rules, both the AAA, ICDR, and JAMS International general rules, the provision that gives the arbitrator authority to set schedules and run the case in any way, that is best suited. And we adopted some of those rules back when we figured out we needed to because of the pandemic, because we needed to give the arbitrator the authority, if appropriate, to order remote hearings rather than allow parties to say, well, if we can't get it together in person, we'll just have to push this off till forever. And that would be the party that didn't want any relief. So I like the idea, as you were saying, Theo, of having the arbitrator have the authority. Now, another very important area, and Duarte or Theo, whoever wants to jump in on this, is confidentiality. Technology arbitrations are replete with confidentiality. The stuff coming in, the discovery, that which is being exchanged, that which may be trying to, I hate to use the discovery in front of a lot of European or, arbitrators who don't like American style discovery, but the information exchange. And even if there is some being obtained from third parties, how do you get that to be under a protection of confidentiality? And then that which goes out when orders are issued or the award at some point. I have an award now in which the parties have requested, I think, 4 different versions: outside attorney's eyes only, attorney's eyes only, which can include in-house counsel, parties only, and a general award. And there's cutting and pasting and redacting. But what can you do to try to protect the trade secrets that may be involved, or, as was discussed earlier, the source code that's at issue and what you're saying about it? Do either Theo or Duarte want to comment on how you handle confidentiality issues? Oh, and Patricia is back. And Patricia, we see you back. So I'll give you a second. I just finished asking them about, asking Theo and Duarte about confidentiality. If you heard that after they speak, you can jump in. And Theo did talk in your absence about the importance of having rules or provisions, even the general rules, that give arbitrators the authority to to control the proceedings and require certain procedures. So confidentiality, how do we protect that which comes in and that which is going out?
I could jump in that from just to, well, firstly to say about that experience where I had to look into the source code and other cases that I have already had in the past. I had a very strict and thorough NDA in place before I started to look into the technology. And this is of course fundamental, but you can have all sorts of NDAs, non-disclosures, obligations, and so forth. But at the end of the day, if you don't have a very muscular agreement in place, all the information that is exchanged in the proceedings may be disclosed to the public. Why? Because it may happen that one of the parties is dissatisfied with the outcome of the arbitration and challenge the award in court, and therefore it goes on to produce all the documents and all the information before the Court of Appeal, if the appeal is available, or before the Court of Annulment, and this can well happen. In some jurisdictions, and I'm now recalling Brazil, and Paul Mason here can tell us better. There is a law under a commission that is evaluating a change in the Brazilian law of arbitration to the effect that all arbitrations are public. So every detail, every document, information that is exchanging during the proceedings becomes available to the public, and that may be a killing shot to arbitration in Brazil. I don't know, but Paul.
I think I could intervene just for a second on that, since I live here in Brazil and I've worked with arbitration.
Yeah, that was the reason I was calling you.
Thank you, Duarte. No, this is a PL, a projeto de lei, a draft bill in the legislature would be the English equivalent, but I don't think it's going to go very far. I think, well, the arbitration community obviously doesn't like it. It has other things that they don't like limiting the number of cases an arbitrator can have at one time, and some other things that don't belong so well in private arbitrations. So I don't think this will go very far. That would be my comment on that.
But in any case, thank you, Paul. In any case, it reflects some trends that may flow from, for instance, arbitrations involving public entities, and arbitration. For instance, here in Portugal, arbitration is highly criticized because it's told to be a way to solve mechanism in private chambers under the secrecy, and as the Romans called sub rosa, which was a procedure to keep confidentiality. Of course, nowadays we cannot use that roles to be hung in the during the proceedings, but of course we need to have very strict and powerful provisions in the arbitration agreement, and there on the terms of reference, or the procedural order number 1, so as to protect confidentiality of these informations. But again,
yeah, just to supplement, when you talk about public entities in Brazil or elsewhere, of course, there's a transparency element that is necessary. So
exactly.
It's already in the amendment to the Brazilian arbitration law of 2015.
Yeah.
Procedures with public entities are to be transparent. Private arbitration is a different matter, you know. So just
what I wanted to say is that there is this trend that comes from arbitration in administrative arbitration that comes into private commercial arbitration, you know, and people start to level these criticisms against not only arbitration involving public entities, but also commercial companies and normal, regular commercial arbitrations.
Right.
I'll just tag on just a little bit and just say, like, I totally agree with what Duarte is saying, that there's a real difference between privacy and confidentiality in arbitration, and absent, you know, party agreement of some kind or the rules governing confidentiality, arbitration proceedings generally are not confidential. So in that regard, I'll note that, and this is not a criticism, the various AAA rules that govern, for example, consumer proceedings, employment, and commercial, they kind of treat confidentiality differently. In the employment, there's an explicit rule about confidentiality in the sense that it actually obligates the arbitrator and the AAA case manager to maintain confidentiality, but it says nothing about the parties. In commercial cases, however, until recently, there's nothing said about confidentiality other than the ability of the arbitrator to issue confidentiality orders if necessary. In the new set that just came out on September 1st, they've now inserted a new rule R45 that basically mimics the rule 23 in employment cases, so that the arbitrator and case manager now are obligated. And we were obligated through other mechanisms as well, because we have to, you know, agree to a statement of responsibilities with the AAA when you take those cases. But this is all to say that Duarte is absolutely correct, that without some sort of rule agreement of some kind, and I note that Michael Lampert also included a company that I'm not familiar with, but if that's a company that allows parties to enter into NDA agreements, without that in place, there wouldn't be anything confidential. And Barbara, to your question that you asked at the beginning, how I handle it really is that I raise it raised the issue immediately at the preliminary hearing because I know that it's going to be an issue. I want to know if that's something that I need to be aware of. And I asked the parties if they need something more than what the rules or their agreement provide. And if so, if they say yes, I say, look, I think you should try and confer about that and see if you can reach agreement. If you can't, then one of you should file an application with me. And I point to the fact, at least in the United States, there are many, many versions of stipulated protective orders and confidentiality agreements and NDAs that are floating around that most litigators who are sophisticated and who practice, particularly in technology cases, ought to know about. So I don't need to provide them any samples. They have plenty of these samples. What I try and get them to understand is don't go overboard with the agreements. There's the 1-tier, the 2-tier confidentiality. The 2-tier creates lots of problems, externalities with third parties and also at the hearing. So it'd be better if you try and keep it simple. But the idea is that if they need to come to me requesting a confidentiality agreement or order, they're welcome to do so. Otherwise, they should just be on guard that it is basically public, absent anything else in place.
Margie, also, I just to finish the thing about Brazil a little bit, we have a brand new member. I'm very happy to welcome Christine Santini from Brazil, who's attending this meeting now online. She's a former high-level judge in Sao Paulo. She certainly knows the Brazilian law a lot better than I do. And she says this, just about what you brought up. She says, I heard yesterday that the draft bill, the PL, is not even going to be discussed this year in the Congress. And the Congresswoman who launched it was not reelected. So we have hope that it's not going to be approved. So to close the door on that, at least in Brazil for now. Thank you.
Yeah, thank you. And I had
Illuminating.
a quick question for Michael Lampert, which is, so what is one NDA? You mentioned it. Are you familiar with it, or were you asking in case any of us were familiar with it?
So, can you hear me? Can I come through?
Yes.
Okay. So it's something I was introduced to within the last week.
We can't see you all of a sudden. We can see your screen, but not you.
Hold on.
Try again.
Yeah. How's that?
That's getting better. Thank you.
Okay. So it was something I was introduced to in the last week, actually. And if you go to the website, there are a group of companies identified at the bottom, including PwC, UBS, EasyJet, Diago, a whole group of companies. And apparently they decided that it was time to sort of see if there could be a kind of universal, or at least presumptively universal NDA that, because sometimes they're the people who want to keep secrets, sometimes they're not, whatever. So it was a collaborative effort to come up with a document which parties can just agree to, which nobody feels like the other side is trying to gain some advantage by proposing, because it's a group product. It's not designed to help any particular player in any particular dispute. I've not had the time. I've downloaded the NDA. I've not had the time to sort of read it and tell you what I think of it. But apparently this effort has been going on, and if you look at the website, it says there are over 600 companies that have signed on to agreeing to use one NDA, or at least presumptively, right?
Well, that says
Michael, could you post the link to it for all of us?
There should be, the link should be in the chat.
It's in the chat.
Oh, okay. Oh, it's in the chat. I didn't look at the chat.
Okay. All right. So Patricia, you abandoned, you left us and now you're back. Did you want to follow up any more on anything that you didn't get a chance to address?
Well, I'm very interested in confidentiality, but let me just sum up, going back, that one needs to make a big distinction between emergency arbitration, which is to get special interim measures from a appointed emergency arbitrator, as compared to expedited arbitration, which is this fast track systems for arbitration. And so they're usually opt-in procedures, or in some cases rules, depending on the institution. And interestingly, you can combine those. So you can have emergency arbitration followed by expedited arbitration. And even under the UNCITRAL rules, you could end up in a situation where you later opt out of the expedited into the regular rules. And if this new adjudication comes into play, that idea, which is being tossed around, is it would provide for a super fast expert being appointed, which is not at all the same as a tribunal secretary, a very different mandate and tasks and qualifications. But that would be a pre-arbitral proceeding, which could happen before or after an expedited arbitration. Emergency arbitration. So you have this expanding toolbox, which would provide many different mechanisms. And there is a real risk that those mechanisms would start to create conflicts and a long and tedious road before you get to a final binding award. And back to the speed, we all know that not all startup disputes have both parties wanting to have a quick result. Not all startup disputes are not complex. There are some big complex disputes which are not at all suitable for quick, expedited, fast track. It can happen. You can have emergency arbitration more than one. I've seen cases with 2 or 3 applications before you even get to the arbitration. So we need to have tools that can be adapted to the specific case, including confidentiality tools.
Thank you. Yes, and as I mentioned earlier, I picked up a case last week where within days of being appointed, there was a dispositive motion on file by the claimant and a request for injunctive relief emergency by the claimant. So we see these things in technology cases where they are at risk of losing in their technology because of, for one reason or another. And so that raised as a question, because when I looked at the UNCITRAL proposed EAP deadlines, it did take my breath away a little. It said that the award shall be issued within 20 days of the constitution of the arbitral tribunal.
Wait, let me just cut you off and say that's the adjudication proposal, which and that's why the mandate from the commission is that this should be built on the basis of the EAPs, but they're different. Under the expedited, it's 6 months from the constitution of the tribunal with an opportunity for a 3-month extension. After that, it requires both parties to agree to any further extension. And in an exceptional case, it could convert into regular if that would mean that the arbitrator's mandate would expire and the whole thing would crash. So this super short is what they call the first stage adjudication, which would only be contractual. And then if there was a dissatisfaction, a party could then file for the arbitration. And the idea, so that's why those are super short. So the toolbox is getting pretty complex. And
if
let me just
trouble understanding them. What do we think the lawyers and the parties are doing?
Exactly, especially when the dispute is in a very contentious and fast-moving stage. And one of the things I can just mix in is because we have this idea of mixed mode, which is very popular now, mixing in the multi-tiers and other mixed mode. Now the kind of new entry is that is that you could have a procedural advisor assigned at the outside of a dispute that would help the parties to understand the procedural steps and work with the tribunal and the parties to explore what these things were. So we're just layering on another potential.
I don't
layer
think it's
into the
good for
process.
arbitration to keep making it so complex that that they have to get advisors to tell them what to do. It looks like we have a question coming from the floor.
Hey, Barbara, can I ask a point or maybe make a statement when you talk about confidentiality? And I see this a lot, particularly in international matters, but also in domestic matters, is that in some of the issues dealing with technology, they are covered by the technology as such that you have to have permission from the government to export or import the technology. In the US, the rules are covered by the State Department and the Commerce Department, but there are rules across the globe with governments. And it's particularly, has to be recognized, not just in the arbitration procedure itself, but also in the transfer of information potentially when you're selecting counsel, when you're selecting arbitrators, discussions, and it just doesn't go down to the attorneys. Licenses at times have to go down to paralegals or even to administrative personnel working within law firms or agencies. So it can catch you, and it's really outside, a little bit outside the scope of what you traditionally think about confidentiality. But some governments today, particularly the U.S. and some in Asia, are they were tough on it before, and they're getting tougher on it even now. So I just wanted to add it.
No, that's very valuable because none of us would like to find ourselves being arrested for having disclosed confidential information across borders without proper authority. I heard the same thing discussed the other day with regard to getting arbitrators' fees transferred across borders sometimes when there are currency restrictions. So it's tough. In the few minutes that we have left, we did start early, so we'll bring this in early too, on time and under budget. I wanted to raise one point that Patricia made, which is there a role for multi-mode dispute resolution in these technology cases? I am a big fan and proponent of multi-mode dispute resolution because when you get, in my opinion, when you get into some of these complex cases, there may be avenues to mediate or resolve some part of the case, which then streamlines the case somehow, or you arbitrate something and then you mediate the rest. And I often raise the issue at the very beginning, especially if time is of the essence, especially if the parties are, hassling over some sort of technology that they might actually benefit from being able to resolve this dispute quickly and then work together. So has anyone on the panel or anyone in the room or on the screen had experience with using multi-mode dispute resolution in technology cases? And what do you think of it? And have you had good experiences or bad? I've had some lawyer arbitrators tell me they would never use it, that they're an arbitrator, they're not a resolver, they're not an adjudicator, they're not a mediator, but nonetheless, I keep trying. Anybody else want to speak up on it? Oh, come on, there must be somebody who's used it. All right, well, Duarte, you unmuted.
Yeah, I was just about to say that I have never had any case like that. So I'm not particularly a fan of that because you run the risk of being challenged once. I mean, if you start as arbitrator and then you go to mediator, most of the times you can come back to the original hat of the arbitrator.
One thing.
A letter,
Barbara.
I have an agreement that I send to the parties, which is the arbitration mediation agreement in which they agree. And so I don't do it unless they, they've agreed and they're willing. They agree that they will not seek to disqualify the arbitrator if after because she or he has been a mediator. And if in the event that the mediation is not successful or some part of it, or we return to arbitrate all or part of the matter, that they will not seek vacature of the award on the ground that the arbitrator operated as a mediator and had ex parte communications with the parties. What I've found is I think almost all of the times I've done it, it has settled in mediation. And I attribute it to one reason, which is when the parties are listening to the arbitrator, who is now their mediator, at some point say, that issue is, and then comment is tough, is difficult, is a problem, is not a problem, whatever. The lawyer may say to their client, normally when a mediator tells me that something is strong or weak, fine, that's his or her opinion, but we are getting an inside look at what the arbitrator is thinking, and that's helpful. And on other occasions, people have asked me, don't you learn things during the mediation that could bias you one way or another? And in my experience, what I've learned is if it's relevant information, it's going to come out in the arbitration anyway. If it's irrelevant, I'm not a juror. I'm not a lay person. I know I can hear something irrelevant and say, yeah, that's irrelevant. I know you're just doing that to muddy the waters. What I do learn is a party's risk tolerance. Are they willing to roll the dice for everything they've asked for? Or do they feel that, no, we do think we have a strong case for all this, all the relief we've requested, but better safe than sorry. We'll settle for some percentage of it. And likewise, the respondents' response is, well, we don't think we have any liability whatsoever, but better safe, we'll pay something to resolve this here and now. So I've learned about risk tolerance, not about how strong or weak they think their case is.
I think
Interesting.
it's the same neutral. Sometimes you can use a different neutral for each one. And
I was just going to say that actually, that,
cases that
Barbara,
come from, sorry.
Yeah.
go ahead, Paul.
Cases, yeah, just quickly, cases that come from China, especially, they're very accustomed to using the same neutral. And it's in the culture, as much as the legal system, to use the same neutral for efficiency reasons and also Confucian-like philosophy of harmony in the proceedings. And not just all kind of cases. That if you're dealing with a Chinese entity, that's probably going to come up as an option. There are ways to also, as Barbara was suggesting, there are ways to get around this issue of the same neutral and getting disclosed things in a caucus, which might bring up due process issues in a Western world by, for example, hearing a case, writing an award, sticking it in a drawer, not publicizing it, and then mediating. There are different suggestions that have been made about that. How that works with tech cases in particular would be a good subject for a follow-up program.
Yeah, I was going to say that. Sorry.
Go ahead.
Oh, I was going to say that, Barbara, I interpreted your initial question actually broader than simply the switching hats issue, which is obviously one way, and it does raise a host of issues that can be resolved through agreements and informed consent and the like. But you can also have what Paul just mentioned, which is the standby mediator or mediation in parallel, or even as an arbitrator sitting on a case, tech or otherwise, to create a specific mediation window. And encourage parties to use that process. So in that regard, you're essentially embarking down a multi-mode process. You're not necessarily going to be the one sitting in the mediator's chair, but you're encouraging parties to consider another process in parallel with the one that they are in front of you with.
Yeah, and I was going to add exactly the same thing, that most of the rules that provide for mediation windows, for example, the C Act, there's a number of them, they provide that the mediator is going to be someone else. And I've seen challenges to arbitrators when the arbitrator has acted as a mediator and the parties, or suggested it, saying that the parties feel that being suggested by a arbitrator, that arbitrators take on that role, that the parties are over a barrel about saying, no, we don't want to do that. And particularly if there's any kind of ex parte communication with the arbitrator, which the other party is not able to know the content and nature of. And so if the arbitrator gets challenged, it's a disruption then in the midst of the proceedings. And if the arbitrator survives the challenge, which I understand, Paul, I completely agree, when we're talking about Asia and different other cultures, that's not maybe a problem. But if they survive the challenge, depending upon your rules and your seat of arbitration, it may come back as a challenge to due process on a set aside or enforcement. So you have potentially 3 times that the proceedings will end up getting disrupted over a complaint about essentially the same behavior, which may or may not be allowed. It may be considered that the decision of the challenge is binding on the decision of the due process at the seat of arbitration, but they're really 2 different legal issues dressed up from the same facts.
Plus, there are different processes that require individuals with different skills. There are a few people that can do both, but it's not automatic by any means.
Yeah, I think, well, so as was suggested, I think this is a great topic for another session. We've come to the end of our time. I know there is a program following us, and I'm sure everybody attending would appreciate 10 minutes to stand up and stretch their legs. So may I turn this back over at this point to the room? The real live room?
Certainly.
I think I would like to thank
Oh, there you
Barbara.
are.
I'm here.
Okay. good.
I would like to thank very much Barbara and the entire panel, Theo and Duarte and our distinguished professor from Scandinavia. Notwithstanding the problems that Patricia had, it all came through, and I learned a lot. I think everybody learned a lot, and I also thank the suggestion for another program. And I will be talking to Bill and our committee, and I think that's a very good idea. So thank you all.
Thank you so much to all of you for participating remotely in that. We really appreciate all your thoughts and insights. Why don't we take a 10-minute break now, and then we'll get set up for our final panel, where we have the honor of having guests here with us today from the Singapore International Arbitration Center, as well as from JAM. So we will do some work to move the cameras around and get set up for that. So let's take a 10-minute break, and then we'll get back to it. Thanks, guys.